Hello, everyone, and welcome to PCR's February Tips and Virtual Transition Times meeting. My name is Melissa Wyman, and I am PCR's Respite Care and Community Engagement Director. I will be your moderator this evening, so please feel free to send any questions or comments in the chat box below. We are so excited to be collaborating with Montgomery County Public Schools MCPS Transition Services Unit to provide an enhanced transition times and tips program for transitioning youth, their families, and caregivers. We are delighted to offer this presentation with American Sign Language simultaneous interpretation. We will also be offering this presentation with Spanish simultaneous interpretation and Amharic simultaneous interpretation. In order to access the different languages, you can go to the Zoom on the bottom where it says interpretation, and you can listen in English, Chinese. So Chinese is going to be Amharic, and then the Spanish channel. The English and Spanish language versions will be archived on the PCR website Transition Times page. Just some Zoom tip reminders. We are using the webinar platform. We will wait for questions at the end of the presentation, but feel free to submit any of your questions in the chat box below. Click Show Captions.
Can we just remind folks that to get into the interpretation rooms, you have to go down to that little globe on the bottom right of your screen. Click it on. And there are three options: English, Chinese, which is actually Amharic, and Spanish. Thank you.
Thank you. Margie, you can't hear me? Okay. We can't hear you.
Yes, I'm watching away in the middle.
All right, hold on one second. All right. Okay, so tonight we are fortunate to have as our presenters. Hold on one second. We have Daniel Cardall is going to get started. So Daniel.
Okay, hello. Good evening. I'm audible, yes?
Yes, you are audible.
Great. Okay, thank you very much. Well, good evening, everybody. I'm excited to be here. My name is Dan. I'm a lawyer. Enough about me. I'm going to jump right in and talk about the Family Law Self-Help Center. Title of this presentation is called It's not called Guardianship. It's called Guardianship with a question mark at the end. And the subtitle is If, When, Why, and How to File a Petition. And the if is very important here because a lot of people will tell you that you have to file for guardianship, that it's imperative, that a responsible parent of any child with developmental differences will absolutely file for guardianship. And I just want you to understand that that is not necessarily true. Many people don't file for guardianship and things work out just fine. Many people do file for guardianship and things work out just fine. The key is to always keep in mind that question mark at the end of guardianship. Should I do it? So that's where we begin. Next slide, please. Question number one. So as I just said, that's where we begin with whether or not I should file. And that, again, that's the question that you start with. I am going to present all the slides as questions. So if you're looking for answers tonight, I'm very sorry. I don't have answers for you. I just have questions. And question number one, again, is should I file for guardianship? There certainly are alternatives, and keep that in mind for the next 40 minutes or so as we talk. Okay, next slide, please. All right, well, what is guardianship? Guardianship is a formal court process. And I use that word very purposefully, process. Okay, so a lot of times people come in to the self-help center where I work, and they ask for that guardianship paper. Just if I could do the paper for them and get the guardianship done that day, all right, that would be great, all finished. But no, alas, it is a process. It takes anywhere from 3 to 8 months, depending on a variety of factors. And guardianship is obtained after getting a court order, which can only be given by a judge, after notice is given to all the interested parties, and after you attend at least one hearing. So again, guardianship is a process. Okay, next slide, please. All right, question number 3. Ooh, true, false. All right, this is exciting. True, false. So to get guardianship, I have to, number 1, decide if it's reasonable given my family dynamic. 2, obtain doctor's certificates. Number 3, do a petition, file a petition with the court and pay a fee, serve all the interested parties, and attend at least one hearing. True, you have to do all of those things. So again, obtaining guardianship is a process. It's not very laborious, but it does involve a lot of work. Next slide. Okay, question number 4. Is there more than one type of guardianship? Yes, there is guardianship of the person, which is caring for the basic needs of the individual, where they will live, what kind of medical care to receive, those kinds of things. And guardianship of the property, management of the significant financial affairs of the person, of your child. Now, one person, you, for example, one person can be both guardian of the person and guardian of the property, or just guardian of the person, or just guardian of the property, or multiple people can be guardian of the person and guardian of the property. So there's a little bit of mixing and matching that can be done. The common scenario is that mom or dad, or mom and dad, are the co-guardians of the person, and sometimes mom and dad, or mom or dad, are guardians of the person and property. Next slide, please. Okay, question number 5. What is the legal standard to get a guardianship of the person? Well, we're not going to chew too hard on all this legal mumbo jumbo, but the important thing to understand is that there is a legal standard, meaning you have to go to court and prove things. You can't just get guardianship because you want to and because you think it's a really good idea for your child and you love them so much and you heard you really need to do it. It's not just walking into the court and getting it automatically. There's a standard you have to meet of clear and convincing evidence, which is a relatively high standard, that your child lacks sufficient understanding or capacity to make or communicate reasonable decisions regarding their person, okay? And that no less restrictive form of intervention is available. So that's the standard. Again, no need to really memorize it or chew on it. Just know that there is a standard, and you'll have to meet it when you file a case when you go to court. Next slide, please. Okay.
On 1 second, I just need to, I got signed out real quick. Okay. All right.
All right, question number 6. What is the legal standard to get guardianship of the property? Well, similarly, that there is a standard that you have to meet, and you have to show that the person is unable to manage their property and affairs effectively. Now, I'm going to pause here for 30 seconds. When you're filing for guardianship, more and more courts are saying, at least this court here in Montgomery County, are saying that unless there is really substantial, significant, larger amounts of property to manage, the court does not prefer you to file for guardianship of the property. If the only property to manage is the Social Security income that your child might receive, then there's no need to be the guardian of the property because you will already become the representative payee by federal law of that Social Security income, and you can manage that without being a guardian. Now, that being said, of course, if you want to file and be guardian of the property because you believe that there is some property to manage, or that there soon will be, or that your child might work someday and earn money and you want to be a part of managing that, then by all means, you can file for guardianship of the person and property as well. Okay, all right. Question number 7. Next slide, please. All right, question number 7. If my child wants to contest my attempt to get guardianship, what rights do they have in doing so? Well, it turns out they have a lot of rights. They have the right to be notified about the case formally. They have the right to a lawyer. They have the right to attend hearings at a time and place where they can access the hearing. They have other rights as well, like asking for a jury trial and things like that. But those are very, 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 very infrequent and not really things to usually worry about. But just know that as a technical matter, that when you file a guardianship case, your child technically becomes your opponent, technically, legally, in that case. And they have rights to stand against the guardianship if they choose. Okay, next slide, please. Okay, question number 8. I'm thinking about filing for guardianship. Who are the parties to a guardianship petition? Well, obviously, the petitioner, or, as I said before, the petitioners, which might be you, that might be, in addition, the other parent. It could even be a third person, although that's very rare. And the law does not favor lots of guardians because that kind of defeats the purpose, right? The idea of a guardian is that one or two voices speak authoritatively for your child as they grow into adulthood. Then there's the respondent. The respondent is your child, who is technically called under the law an alleged disabled person. As the case begins, that person has what is called the presumption of capacity, meaning that they have the presumption as an adult to manage their own personal affairs and their own financial affairs as well. And you, as the petitioner, bear the burden of showing that they lack that capacity. Other parties in a guardianship case are people called interested persons, which means a variety of different things, and we'll get to that in just a moment. Next slide, please. Okay, question number 9. All right, who are interested persons? All right, well, interested persons includes the other parent, first and foremost, which sometimes is not an issue or a problem, but sometimes it is. Because maybe sometimes you and the other parent are not necessarily playing ball on the same team in terms of what's best for your child, or maybe you've lost touch. In that case, that becomes sort of your first hurdle in a guardianship petition, because that other parent will have to be located and properly served, properly notified about the case. But they are an interested party, meaning that they are a required party in a guardianship petition. Other interested parties include adult siblings, if any, a spouse, if your child happens to have a spouse. Interested parties include entities like the Social Security Administration and the Department of Health and Human Services. Okay, there's some technical things regarding interested parties when you involve guardianship of the property. other potential beneficiaries of the fiduciary estate. We're not going to get into that right now. If there's a large hunk of money that's to be managed and you're concerned about that as a guardian of the property, that's probably when it's time to hire an attorney to assist you with the case, and maybe even a financial planner as well. We won't get into that tonight. All right, next slide, please. All right, question number 10. Well, do these interested persons have rights too? Well, yes, they do have rights. Most importantly, they have the right to notice. And that sounds like a pretty harmless and innocuous thing. Oh, yes, but until you have to actually serve them, which will take some time, cost you some money, and might be a little bit complicated and confusing. So the interested parties all have to be properly served and notified. Interested parties can come to court and object to the need for a guardian. Interested parties can also come to court and object that you should be the guardian. They can come to court and say, no, not this person. Don't let the petitioner be the guardian. Make it be me, or make it be somebody else, or make it be a public guardian. Make it be someone that the state puts in. Not very common, but interested parties do have that right. Also, post-appointment, meaning after you become the guardian, interested parties technically remain in the case and can petition the court to do things like remove you as the guardian if the interested person has good reason as to think that you're not being a proper guardian anymore, or ask for other appropriate relief as well. Again, not very common, but they do have that right. Next slide, please. Hey, let's look at a guardianship petition. Okay, well, we're not going to do a guardianship petition. We're not going to spend, half an hour doing that. I just want us for a minute to, and this was given as a handout. We're just gonna, you can leave the slide as it is. If you don't have a guardianship petition in front of you, which likely you don't worry about it. I'm just sort of mentioning this to say that this is a 7-page document, which is not very mysterious, not very scary. I'm going to take 30 seconds and just kind of, not that anyone is mystified by it, but if you are, the first page just has names and addresses. The second page just has questions about whether or not you as the potential guardian have committed any crimes of fraud or violence. If you have, just be truthful, no big deal. You can explain in court as to maybe why that happened. It was a long time ago. Everything's good, judge, don't worry. Just always be truthful on these pleadings. The third and fourth page just ask about interested parties, such as other parent, adult siblings, other government entities, things like that. The fifth and sixth page just get into discussions of, for example, why it is that your child needs a guardian of the person or needs a guardian of the property. And it'll ask you questions like, what other less restrictive alternatives have you tried that have not worked, such that guardianship is your last resort? And really, that's kind of what the law wants to see. The law wants to see that the rights of your child be fully protected, that they have the fullest amount of self-determination as possible, and that a guardianship order should only be issued really kind of as a last resort. And that is really pretty much a guardianship petition. The last page is just signatures and other information like that. And that's how you do it. Again, you're welcome to do guardianship petitions on your own. You can, of course, hire your own lawyer to assist you and pay that person. Or, like I said a while ago, you're welcome to walk into the self-help center where I work any day, Monday through Friday, starting at 8 o'clock in the morning, sign in, wait, and meet with a lawyer who can help you start your case. Okay, next slide, please. All right, question number 11. What are certificates of, well, they're called now certificates of incapacity or certificates of capacity. you might have heard about these, and certificates of capacity are where you start. So if you're thinking about filing a petition for guardianship, always think, okay, I need to start by getting these 2 certificates of capacity. Now, what does that mean? Well, you need 2 of them. One of them has to be by a doctor, any MD will do. And the second one can be by a second doctor, or the second one can be by a licensed clinical social worker, or a psychologist, or a nurse practitioner. But you need to have 2 medical certificates. Now, they are called, actually currently, historically, they were called certificates of incompetency. Then they were changed to certificates of incapacity. Then they were changed to certificates of capacity, which is confusing because the point of these medical certificates is to show that there's a lack of capacity on the part of your child to manage their own affairs and to manage their, whether it's their personal affairs or their financial affairs. So again, where you begin is to obtain the blank forms of certificates of capacity, schedule 1 or 2 doctor's appointments, and tell the doctor ahead of time, okay, the purpose of this visit is for you to evaluate my child and do these certificates so that I can file them with the court. And sometimes, like I said, you'll need to make 2 appointments with 2 different doctors because the court is going to want 2 of those certificates. The other thing to keep in mind about the certificates, and this is very important, so please remember this, the certificates expire quickly. They last about as long as a gallon of milk in your refrigerator, only 21 days. So once you get certificates of capacity or certificates of incapacity, understand that you need to very quickly come to court and file and do a petition for guardianship. Otherwise, the certificates will expire and then they're no good anymore. You've got to throw them away. All right. So remember about the certificates, that's where you start. You need 2 of them and they expire in 21 days. So come to court with the certificates to do the petition, and then you have a case. Okay, next slide, please. Okay, question number 12. I've done a petition. Now, which court do I file it in? All right, well, you file all petitions for guardianship in the circuit court. You know, there's a lot of courts around here and around the world. You file the petition in a circuit court in the county in which your child lives. Now, if you're thinking of moving anytime soon, particularly to another state, I would encourage you, rather than filing a petition for guardianship here and then having to transfer that in the near future, if you're thinking about moving soon as your child turns into an adult and turns 18, I would suggest holding off and filing wherever it is that you move to, because transferring cases or transferring a guardianship order is relatively complicated and sometimes gets people stuck. So I just tell people, if you're thinking about moving, and you're going to move, hold off on filing a guardianship petition until you actually move. All right. Next slide, please. Question number 13. Okay, another true-false question. True-false. I filed and I got show cause orders in the mail with a show cause hearing date. What does show cause mean? Oh, anyway, we'll get to that. I've got show cause orders in the mail with a hearing date. I'm good, right? I just show up at the hearing, right? False. That's wrong. And this happens, unfortunately, all the time. People get the doctor's certificates. They come to court. They do the petition for guardianship. They pay the fee. a lot of work. They get the show cause orders in the mail. They're a little confusing. You read them, okay, what does this say? Ah, at the bottom, you see the hearing date for the show cause hearing. And you decide, okay, I guess I'm good. I just show up at the hearing. Wrong. There's a big thing you need to do in the middle, which is to serve all of the interested parties with a copy of your petition, a copy of the doctor's certificates, and of course, a copy of the show cause orders. Now, exactly how it is that you serve all of the interested parties can range from a variety of different things, including hand delivery, certified mail restricted delivery, and sometimes just regular mail. And exactly how you serve the various interested parties is its own 30-minute lecture. So we're not going to do that now. If you get to this point in your case totally on your own, congratulations. But at that point, unless you're really good about these kinds of things, at that point, you should either walk into the help center for assistance with the service aspect or hire your own lawyer. That's what I recommend. Next slide, please. Okay, question number 14, another true false. All right. So my child will have a lawyer and can actually fight me on this. True. All right. Check out Maryland Rule 10-106A2. What's that? You don't have the Maryland Rules of Procedure in front of you? Well, I do. Here they are. I'm going to take a 10-second look at it. And I'm looking at it, and it says that in situations such as this, the court shall promptly appoint an attorney for the alleged disabled person. Well, there it is. There's that difficult word. Shall. The court shall do it. In a case like this, the court shall appoint an attorney to represent your child. So please, please, please do not do what a lot of people do, which is to come to my office, to the self-help center, wait for 3 hours to be seen, and ask me, can I get rid of that lawyer? I don't like that lawyer. They're not very nice to me. They're being pesky. They just want to talk to my child. I don't like any of this. We're good. Keep the lawyer. Too bad. You're just going to have to cooperate and allow that person the opportunity to meet with your child. All right, now, does this happen commonly that your child fights you on a case for guardianship? Not usually. It doesn't happen very often, but it can happen. Most of the time, your child might not care at all. Sometimes people care a lot, and you just don't know. So you just have to be ready for it and cooperate. All right, moving along. Question number 15. All right, next slide, please. Great. Well, what is the role of the lawyer? The role of the lawyer in this instance is to protect the due process rights of your child. They're entitled your child is entitled to the same due process rights as anyone. There's a lot of rules about guardianship petitions, a lot of rules about a variety of petitions in court, and your child has those exact same rights as anybody else. The lawyer is also supposed to advocate for their client's position, meaning your child, because you're not the client. It's your child. They're supposed to advocate for the client's position, even if that client's position might conflict with the attorney's judgment as to what is best for that person. Now, there's certain ethical exceptions that a lawyer is supposed to follow. If likely bodily harm or other serious things would happen as a result of advocating for the client's position, then the lawyer has various ways to get out of doing that. But just understand that, again, it's possible you won't like this lawyer that's come to meet with your child and potentially fight you in this case. You just have to cooperate. Next slide, please. All right. Question number 16. What is the first hearing and what do I do? All right. That first hearing is called a show cause hearing. Show cause, I don't know. It's old-fashioned language. Well, what do? No big deal. Fairly straightforward. You just show up and you explain to the judge why it is you're seeking guardianship, and why it is that the person you're seeking guardianship over lacks capacity to manage their own care and or their financial affairs. Now, at the show cause hearing, which is the first hearing and sometimes the final and only hearing, you should expect to win and become the guardian right then and there, assuming, of course, that no interested party nor your child shows cause why you should not be the guardian. If that does happen, if an interested person or your child successfully shows cause why you should not be the guardian, then the matter gets set for a contested trial 3 or 4 months down the road. Next slide, please. All right, question number 17. Hooray! I won an order. I can pretty much manage everything now, right? Well, I mean, more or less, yes. Whatever you think is, whatever you might think is most reasonably necessary to manage the care, the comfort, the day-to-day functioning of your child. Yes, you do those things, and you don't have to necessarily think about the particulars, about what exactly the legal standards are as to what you can and can't do. You just sort of use common sense about it. Now, there are some important limits. For example, even though you might become the guardian of the person, you cannot, for example, change the classification of the abode of your child without first coming back to court and asking permission to change the classification of abode. It doesn't mean you can't move. Of course you can move, but if you're going to, for example, move your child from your home to a nursing center, that is a change of a classification of abode. You'd have to come back to court on that. Other things, certain medical procedures that involve substantial risks to life, again, you would need to come back to court and seek permission from the court on that. Another interesting one is a name change. You might think, oh, well, I'm the guardian now. I no longer like the last name that this child has for whatever reason. I'm going to go to court and I'm going to do a name change petition to change my child's name. Not necessarily. That's not the basic day-to-day care and comfort aspect that the guardian has. That would be something that's outside the scope. All right, next slide, please. All right, this is a lot of words, a lot of writing. I'm going to kind of go through this very quickly. You know, as we touched on, guardian of the person has certain rights, powers, and duties. The ones that you would think make sense: determine where, in general, the child lives, determine that person's care, comfort, and maintenance, care for their personal effects, you know, their things, arrange for services for them. If you're not the guardian of the property, maybe there's a guardian of the property that's not you. You can talk to the guardian of the property to ask for money to do things with that money. And then, of course, give consent to medical professionals for routine care of your child. Those are the basic duties of guardian of a person. Just whatever you would commonsensically think that it would be. Next slide, please. Now, again, guardianship of the property. Again, it's a personal decision. There might be a very good reason as to why you think you're going to become the guardian of the property. Again, if so, there has to be something substantial for you to manage. If not, I don't recommend filing for guardianship of the property, but again, that's just a little recommendation. This is totally something that you'll have to decide for yourself. there's various lots of things that the guardian of the property can do with the person's property: houses, cars, boats, retirement accounts, things like that. Obviously, most of this would not apply to your child, but those are the types of powers that guardian of the property has to manage. Next slide, please. Again, this is this dovetails off the prior slide. If you're talking about being guardian of the property, again, you're probably talking more about hiring a lawyer and potentially hiring a financial planner as well. Just for example, you can go all the way down the list. What does it say at the bottom? Things that one of the powers that guardian of the property has. You can donate to a conservation easement. Well, for heaven's sakes, if you're going to use your child's money or inheritance or whatever to donate to a conservation easement, that's beyond the scope of what I'm going to talk about now. That's something to talk to a financial planner about. But other very basic things like paying taxes and other things like that, of course, those are the basic rights of, or the basic duties, I should say, and responsibilities of the guardian of the property. Next slide, please. This is just sort of a summary of what we've already sort of talked about. If you're the guardian of the property, day-to-day management of paying bills, collecting income, if your child happens to inherit property and there's rents to be collected, managing that property, paying taxes, things like that. Again, not usually very common. We're not talking about, gee, I get the Social Security check or some other small amount of income. How do I manage? That's not what we're talking about here. Although if there is going to be regular income that's going to be sizable other than Social Security, probably it is a good idea to file for guardianship of the property as well. Next slide, please. Oh, the lights have gone off in my office. All right, now they're back on. Okay. All right. Guardian orientation and training requirements. Happily, after you file a guardianship petition, and as you're sort of in the meantime of waiting for your hearing, you're required to do a very, very wonderful orientation program that the court requires you to do. You see it there on the website. No need to write it down now. You'll see it again. And then there's another video that you have to do after you become the guardian, and you'll have to complete both of those videos and file with the court the certification that you watched the videos. They're very helpful. They're excellent, full of great information. By the time you finish the case and watch the video, you'll essentially have a PhD in guardianship. Next slide, please. All right, question number 18. Oh, another true, false. All right, true or false? After I get the order, I'm done with all this court stuff, right? False. All right, every year, if you are guardian of the person, you will be required to file an annual report. Essentially, the annual report asks questions for you to detail how your child is doing, who their doctor is now, who their dentist is, what their appointments were, if there were any significant changes to their health care, that kind of thing. It's not very complicated. You also have to do if you become guardian of the property, you will also have to do a fiduciary report, a financial accounting, which the court will send to you, and that is more complicated. It's a pretty involved document. It's kind of a real pain, and if you are not the guardian of the property, yay, happily, you will not have to do that. You'll just have to, if you're guardian of the person, you will only have to do the annual report of the person, which is much easier. Okay, next slide, please. Question number 19. Okay, again, I'm the parent, and I'm just trying to do the right thing for my child with a developmental difference, and I love my child, and I'm the parent, and we're all cool, right? really don't have to do all of this to become the guardian, right? Please show me the shortcut. Just give me the shortcut. Now, you should hopefully ask this question of yourself or to the atmosphere about 5 or 6 times during the initial and middle stages of the process. Because if you don't ask yourself this question, you're not paying attention and you're not doing things correctly, because it is a little bit laborious and it is a little bit onerous. And yes, hopefully you will ask yourself, if you're paying attention, this question: do I really have to do all this? Well, if you're determined to become the guardian, whether it's guardian of the person or guardian of the property or both, the answer is yes. You'll have to do all of these procedures because, as we mentioned half an hour ago, as we're getting close to wrapping up now, this is a process, a court process. All right, next slide, please. Probably I should have put this in the beginning, and maybe next time I'll put this slide in the beginning, but where can I find all these court forms? mdcourts.gov. That's MD like Maryland, courts with an S, mdcourts.gov, where all your forms, dreams come true. You can go there, and it's very easy to find all of these guardianship forms under the family section. Okay, next slide, please. And I think that that's all for me. Thank you so much. It is a great delight for me to be here to present. Thank you so much for your attention. Good luck.
Okay, so I think if you don't mind, we might ask some questions because we have a lot of them.
Melissa, I have them written down.
Oh, perfect.
Most of them. So I can start, and then I have it marked on the chat where I left off. Like I stopped writing because my hand got really tired from all the
Okay, perfect.
I think, Dan, this is Pat Cochran, by the way. I think that you have answered a lot of these, but I'll get started. So what doctors can be used?
Okay, so you have to have one doctor, and it can be any doctor that is an MD, meaning any doctor. It's usually going to be whoever has been the child's main general practitioner. That's the best one. But it can be a gastroenterologist. It really doesn't matter. It just has to be any doctor that will evaluate your child. They can't say on the certificate, they cannot say, I examined this patient 6 months ago and I thought this. No. They have to say, I examined the patient today and I think this today. Signed, doctor, today. This is actually very important because this is a very, very, very common mistake where people, instead of making a doctor's appointment for an evaluation, they just send the papers to the doctor and say, hey, doctor, you saw my child 6 months ago. Just base it on that. And the doctor, trying to be very nice, they'll do it, but it won't work because it's already more than, the examination is already more than 21 days old. The court will reject it.
Okay, number 2, can a revocable trust be appointed guardian of property or person? I assume that means trustee for revocable trust.
Yes.
Okay, that's the answer, yes. Okay, number 3, are financial assets aside from Social Security, and it said Social Security, it may mean SSI, or other direct income, such as ABLE, are they considered property?
Basically, anything of value is considered property. So yes. And I am not certain as of right now, but I'm fairly sure that if you're going to be working with Maryland ABLE, I think that they will want you to have guardianship of the property. You might want to check with them before you file a petition. Property is really anything of value.
So I'm going to put a plug in here because on Thursday night, we're having another event like this, and it is about special needs trust and ABLE accounts. So hopefully you can join us for that one as well. Okay, 4, where can we get the petition? And we did the handouts were shared after that question, so the individual may already have it in the handouts. But where typically can somebody get the petition?
Well, you can always walk in to the circuit courts. If you're in Montgomery County, you can walk into the Montgomery County Circuit Court to the Family Department, room 1460, and ask for the big guardianship packet. And that has all the forms, including the instructions. An easier thing to do, maybe if you have access to a computer and a printer, is just to go to mdcourts.gov and navigate around. It's very easy until you find the guardianship section, and all the forms are there, downloadable, printable, very easy.
Thank you. Are you able to give any information about lawyers that can help fill out the paperwork?
Well, there's 6 lawyers in the Self-Help Center, and you can come here and talk to any of us. Or I don't have, because I work for the courthouse, I can't say, hey, go to Samantha. She's a great lawyer and she'll do it for you. I can't do that. If you're wanting to hire your own lawyer, you would shop for that like you would shop for anything nowadays. You would go on the internet and you would Google guardianship, Maryland lawyer, and do it that way.
Okay. What are the pros and cons of guardianship?
I am sorry, that is an unanswerable question. No, it is. It is. Pros. A feeling of security. You can kind of go to bed every night knowing that you're in charge. Con. You go to bed every night knowing that you're in charge. That pro and con is the same. Con. It's a process. It can take about 6 or 7 or 8 months out of your life. It might anger your child. It might cause some disruption in your family life. Pro, gosh, maybe your child really needs it and they have absolutely no ability to manage their own, for example, scheduling of medical appointments. And without you being the guardian, you'll begin to find as they get older and become adults, you have no more rights to go in there to meet with the doctors, and they're not going to tell you anything. And your child has such significant health issues that you've got to know right from the doctor, otherwise there'll be serious problems. So that's a pro. I could go on and on. The more you learn about it, you'll develop your own pros and cons, and you'll come up, and your pros might be someone else's cons, if that makes sense.
So if you are a guardian in this process, can you plan for your own death? So can you choose somebody to succeed you as guardian, or do they then have to start the whole process again after your death? And what could happen in the interim?
Well, that's a great question. If you yourself are, I don't know, older or have very serious health problems, but you want to be a guardian, it's a good idea to make someone else who you trust and who you can work with a co-guardian. That's an easy thing to do. You both sign the petition, you both go to court, and then if you, as one of the co-guardians, win, you pass away, then the other person is just, they're still the guardian, and now they're the only guardian. You can put Now, so that's one way of doing it. Another way is you can put in your will, hey, I want Stephen to be the successor guardian when I pass away. Okay, but that's not legally binding. Stephen can say, nope, I'm good, and not do it. So you can't require someone else to do that work. They'd have to come to court and file to be the successor guardian. So what some people do, and I'm serious about this, some people don't want to have a co-guardian because they don't like that. They'd like to have the control. Totally understandable. But maybe they're not well, maybe they're getting older. Sometimes what people do is they just take someone else out for lots of cappuccinos, give them information and love, and say, now when I pass away, here's a petition to become the successor guardian. Go do it. And then they go do it.
Okay. Thank you. Must you be a Montgomery County resident to use the Family Self-Help Center, or do they have the same centers in other counties?
Every county has a self-help center. The services vary widely. You would just have to Google whatever county you're in. Now, that being said, anybody from anywhere can come to Montgomery County Self-Help Center for assistance, as long as it is going to be a Maryland petition. Even if that petition is going to be filed in some other county, you're still welcome to come to the Montgomery County Self-Help Center, but you just can't file it here if the child is not living here in Montgomery County.
Good information. Is 21 days, is that 21 calendar days or 21 business days?
21 days, calendar days.
There we go. Okay. So regarding the notes, and it wasn't clarified what notes, what do the notes have to say? What wording is needed? Can you use a school psychological evaluation?
Okay, you are referring to the certificates.
Probably.
Usually a school, well, again, gotta have two. One must be a MD. The second can be a psychologist, as long as they are a licensed psychologist. Lots of times schools have a social worker that could work, but lots of times in schools, the social worker does not have the requisite credentialing. As an LICSW, the letters might have been mixed up there, sorry, but the school social worker might not have the requisite credentialing. That person will probably know if you ask them.
And I will add that most psychological evaluations that come from schools are done by a school psychologist. They are not licensed clinical psychologists.
Right, thank you. And the court, if you are going to use a psychologist, you would still need to use the court psychologist form, as opposed to one that the psychologist might cook up on their own.
How do you handle a medically fragile person who turns 18 and you don't have access to medical records? It says until the court date, or maybe before the court date. I'm not sure what the question.
Great question. And obviously it comes from a place where everybody wants to love their child and do the best thing for them. And that's what everyone here is wanting to do. I don't know. In my experience, gosh, the doctors, they don't usually suddenly shut the door on you when the child turns 18. They usually have a way of smoothing that over. But if not, and there is a genuine crisis of some sort, and you cannot get information and you desperately need information, there is such a thing as an emergency petition for guardianship. But having said that, everyone comes in and says, give me that one. I want the fast one. I mean, there has to be a genuine emergency, because then if every case is an emergency, then none of them are an emergency, and then there's chaos. So, but there is such a thing as an emergency petition for temporary guardianship pending outcome of final guardianship, which of course is the usual 8-month, 6-month case.
Okay, can you give the address of the Family Self-Help Center?
50 Maryland Avenue, Rockville, Maryland. Room 1500, 1500.
Okay, there's another one about medical. We have a lot of questions here, so I'm going to try and move along. Do we need only $165 to file, or are there any other fees?
Likely, well, that is the filing fee. When you do the service on all the interested parties, because there will be likely requirements of certified mail and maybe even restricted mail, that would be another probably $40 to $50. That's probably all the fees that you will have.
Okay, I think most of the other questions, I think that is it. We are going to move on to the next part here. Thank you, Sandy, for waiting. So thank you very much, Dan. That's always so helpful. We really appreciate you taking the time again this evening to be with us. Really, really good information.
You're
Thank
welcome.
you so
Thank you.
much.
All right. You can hear me, right?
Yes.
All right. Well, good evening, everyone. My name, next slide. Next slide. Good evening, everyone. My name is Sandy Ballin, and I am a staff attorney at Disability Rights Maryland on their Developmental Disabilities Healthcare Victims of Crime Act team. Just as a brief background about Disability Rights Maryland, we are Maryland's federally designated protection and advocacy organization for people with disabilities. In our nonprofit law firm, we have multiple teams that focus on different areas of concern. The team that I work on, the DD team, focuses on providing legal assistance when it comes to Medicare and Medicaid issues, and access to DDA services. We also do a lot of work investigating abuse and neglect within nursing homes. And in addition to doing all that work, my area of focus is on providing education and advocacy around alternatives to guardianship, like supported decision-making, which is why I'm here today. So before I begin, just a brief disclaimer. Any of the information I give tonight is purely for informational purposes. It's not to be construed as legal advice, but if you do require legal assistance, you can contact our intake line, and the number is right there, and they will be able to guide you as to the next steps. So next slide. So here's just a brief roadmap of where we're going to be going tonight. So first, I'm going to talk a little bit about the background information, important things to be able to understand. Then the big part of this presentation is going to be about supported decision-making. Then we're going to see how SDM can work with other alternatives to guardianship. We're going to see some hypotheticals, see how SDM can work. I'll discuss some important resources, and then at the end, I left some time for questions. So I will get started. Next slide. Next slide. So I'm not going to go through all of this in detail because it's there is a lot of disability rights history, but the gist of it is dating all the way back to the 1800s. People with disabilities have been discriminated against at a systemic level. Like, for example, in the 1800s, there were the ugly laws that forbade individuals with disabilities from even being seen in public. In 1927, there was the Supreme Court decision, Buck v. Bell, that allowed for the forced sterilization of individuals with disabilities. And actually, to this day, that decision still has not been overturned. And even though we have made strides in the disability rights movement with the inception of the Americans with Disabilities Act, the start of home and community-based services, and even with the Affordable Care Act, a lot of the systemic issues are still currently being witnessed by individuals with disabilities. And it's based off of the belief that they cannot make their own decisions and that they lack what's known as decision-making capacity and legal competency. Next slide. And so what exactly is decision-making capacity? Decision-making capacity is exactly what it sounds like. It's a person's ability to make decisions. And a person's ability to make decisions, it is not a one-size-fits-all approach. It's fluid, meaning that it can increase or decrease depending on various factors. And some of those factors might be what type of decision is being made. Is it a big decision or is it a small decision? It can be when a decision is being made. Is it being made immediately or do you have some time to think about it? Even, especially in regards to guardianship, any supports or accommodations that are being used. So we describe it as being on a spectrum. And on one end of the spectrum, you've got those decisions that require less supports and accommodations to be made. So for example, if you were to ask me when I'm on vacation, it's mid-afternoon, about what I want to eat for dinner that night, I'm not going to need a lot of assistance to be able to make that decision because one, I know what I like to eat, and two, it's midday, I'm on vacation, I'm pretty relaxed. Now, I might need some support in knowing what cuisine is good around there or what food I might like, but I'm still able to make the decision by myself with not a lot of support. But then there are those decisions that require more supports and accommodations. So for example, if you were to ask me bright and early on a Monday morning to make a decision about my finances, let's say about my retirement account, I'm probably going to need more supports and accommodations to be able to make that decision because one, it's bright and early on a Monday morning. I am not a morning person. And additionally, I'm less familiar with finances than I am with knowing what I want to eat. So I'm going to need someone to sit down with me and talk about what options would be good for my goals, what might not be good for my goals. But even with the supports and accommodations, I am still the one making the decision. And when thinking about the alternatives to guardianship, like powers of attorney, they offer the supports and accommodations that allow a person to be able to make their own decisions without having to have a guardian appointed. Next slide. So on the other side of decision-making capacity is what we call legal capacity or competency. So competency is a legal concept, and it is a person's ability to make decisions under the law. So whereas decision-making capacity is about what I want to wear tonight, competency is about making a contract, consenting to a medical procedure. And every adult is presumed competent unless proven otherwise. That is the standard, which means that any decision they make must be recognized under the law. Next slide. And so the importance of thinking about disability and decision-making capacity and legal capacity is that there is a belief that individuals with disabilities lack the ability to make their own decisions because they have a disability. And that belief has led to discrimination in a variety of forms. There's been segregation in institutions, isolations within schools, and especially in the context of what we're discussing tonight, there's a higher risk of being placed under overly broad and unnecessary guardianships. Next slide. So we had a wonderful presentation just now about what guardianship is, so I'm not going to go into too much detail about this, but just as a quick refresher, guardianship is a formal legal process involving the circuit court. Remember, you've got to file the petition, there's going to be a hearing, and then the court releases the order, either granting or limiting or not granting guardianship. And there are two types of guardianship that a person can petition for. There's guardianship of the person, where the person will be able to make decisions related to the individual's personal care. And then there's guardianship of the property, where they will make decisions related to the individual's finances. And like it was said in the other presentation, there is also plenary guardianship, which is guardianship of the person and guardianship of the property. And next slide. And even though in some instances guardianship may be absolutely necessary, it's also important to recognize that there are certain dangers with guardianship. Because once a person is placed under guardianship, they lose the ability to make many decisions for themselves. And those decisions can be related to healthcare or even to their finances. And too often, guardianship orders are plenary and they're permanent, in the sense that once that guardianship order is put into place, it's very difficult to get it terminated or limited. And we even saw this in a real life example with pop star Britney Spears, where she was trying to end the conservatorship that was placed over her by her father. And the difficulties that she experienced are not unique. Individuals who wish to terminate or limit their guardianship are unable to access their medical records. They have difficulty in finding counsel to represent them at hearings. And even if they can find counsel, there's sometimes bias about the individual's capacity to make their decisions. Actually, in Maryland, it was found that attorneys who are representing individuals with diminished capacity were essentially ignoring what their client wanted and instead substituting that for what the attorney believed was best. And as a result of that practice, the Supreme Court of Maryland actually issued a rule change so that now attorneys who practice in Maryland and represent clients with a diminished capacity have to maintain a typical attorney-client relationship, which means that they have to respect the choices of their client. But now the big question is, what if, with the appropriate supports and accommodations, a person can make their own decisions without having a guardian appointed and avoiding these dangers that exist with guardianship? Next slide. And that was the question posed to the Cross Disability Supported Decision-Making Coalition. So this coalition were 27 players across Maryland. It included the Maryland courts, private attorneys, agencies, advocates, and people with disabilities. And DRM was actually the head of this coalition. They came together to create an action plan to advocate for such supports and accommodations. And they're known as alternatives to guardianship. And specifically, they advocated for the use of one alternative known as supported decision-making. So as a part of the 2022 legislative session, the law was created and passed in Maryland that officially recognized supported decision-making as one of those alternatives. And I'll discuss a little bit later about what that meant once supported decision-making was made a law. Next slide, please. Next slide, please. So what exactly is supported decision-making? Supported decision-making, or as I'll refer to it on and off, SDM, is a tool in the decision-making toolbox, just like powers of attorneys are one of those tools, or guardianship is even one of those tools. It is also an alternative to guardianship, and it allows a person to keep the ability to make their decisions without having someone appointed to make the decisions for them. And it can be used in making a variety of decisions, ranging from healthcare decisions to financial decisions. And additionally, it may be used as a reasonable accommodation under the ADA. Just as an aside, a reasonable accommodation is any accommodation that an individual with a disability can use to access services in an equal manner to an individual without a disability. Next slide, please. And so this is a very basic way of understanding how supported decision-making works. But it starts off with having a supporter helping an adult to make, communicate, or effectuate a decision by providing tools and support so that the adult can make their own decision. So when thinking about it in this way, we use SDM in our everyday lives. We just never realized that we've been using it. So as a personal example, I went to law school in St. Louis. So when I moved to Maryland for my job, I was apartment hunting for the very first time by myself. So I turned to the people in my life to be able to assist me with finding an apartment. I turned to my parents who were familiar with the home buying and the apartment hunting process. I turned to my brother who lived in Virginia and could tell me what was realistic in the DMV area. And I also turned to my new coworkers who were more familiar with Maryland and could tell me which areas were suitable for people my age, which areas were close to work. And I got all of this information from the different people in my life, but I was the one who made the ultimate decision, and I was the one who signed the lease. And that's the key to supported decision making, is that the adult is the one who is making the ultimate decision, regardless of what their supporters believe. And let me tell you, in that personal example, my parents were not happy with that first apartment choice that I made, but the important part was that I was the one who made the decision. Next slide. And so what is this supporter? A supporter is a person who helps the individual make the decision. That can be family members, friends, support staff, or professionals. But again, their main role, whoever that supporter is to help the adult in the decision-making process. The supporters do not make the decision for the adult. If you are going to get anything out of this presentation tonight, it is that the supporters do not make the decision for the adult. Additionally, the individual making the agreement chooses the supporter and how the supporter will help. In a supported decision-making arrangement, there can also be more than one supporter. So one supporter might help with healthcare decisions. Another supporter might help with financial decisions. Additionally, a supporter can resign or be removed by the adult at any time. Next slide, please. And so what are the responsibilities of a supporter? Again, the most important responsibility of a supporter is to help the adult make, communicate, or effectuate a decision made by the adult. They do not make the decision for the adult. They can offer advice, create pros and cons. They have to act honestly, diligently, and in good faith. And they also have to support the wills and preferences of the adult, even if the supporter disagrees with what the adult does. Next slide, please. So supported decision-making is a larger concept, and states around the US have actually started recognizing it under their law. In Maryland, again, that came about in 2022. So now SDM in Maryland is officially recognized as one of those less restrictive alternatives to guardianship. So courts have to recognize that this has been used and failed before they can impose a guardianship order. It is a way to limit, terminate, or avoid guardianship altogether. And it can also be used informally or verbally, or formally, meaning through a written and signed agreement. I will talk about a little bit more about those formal elements in an agreement, but again, this is just specific to Maryland, that it can be used verbally or in a written way. It can also be used with other alternatives to guardianship and even with guardianship orders themselves. Next slide, please. So as I said, in Maryland, an SDM arrangement can either be an informal in a verbal way, or it can be formal. These are the elements if you decide to create a formal SDM agreement. In Maryland specifically, there is actually no specific form that needs to be used. However, it has to follow these specific elements in order for a formal agreement to be valid. So first, it obviously has to be documented in writing and dated. It has to name at least one supporter and describe the assistance they will provide. It has to have specific language about the supporter's authority. And it has to describe how the supporters will work together if there is more than one supporter, because remember, there can be more than one supporter. So it can either be jointly, meaning together, or it can be successively, meaning that if supporter 1 is unavailable, the adult can turn to supporter 2 to help in the decision-making process. Additionally, you have to describe any perceived or actual conflict of interest between the supporter and how to resolve or mitigate those issues if it exists. You also have to document how the adult selected the supporter. So for example, I select my mom to be a supporter for my healthcare decisions because she is a nurse. It also has to state that the supporters cannot make the decisions for the adult. Again, one of the most important parts of an SDM arrangement. It also has to state that the agreement does not affect the authority of an agent under a power of an attorney. It has to be signed by the individual and the supporters, but it also has to be signed and witnessed by two individuals who are not the supporters or agents and employees of the supporters. Now, if you look at it, please notice that there are two things that are missing. One is that an attorney does not need to be involved to create a formal SDM agreement. Additionally, you do not need a notary to be able to create one. Again, for the formal SDM agreement, there is not a specific form that needs to be used. But on DRM's website, we do have a sample template that includes all of these elements that we give out to clients who are interested in creating an SDM agreement. The nice thing about that form is that it is editable because it is a Word document. So if for a certain task, an individual does not want a supporter, they can edit that form down. Next slide, please. So another question I get asked a lot is why choose an informal agreement versus a formal agreement? And so for informal agreements, the pros of it is that it is less prescriptive, it is easier to change, and additionally, if an individual chooses a professional as a supporter, a professional may be more willing to act as supporters if they don't have to sign an agreement to do so. But then for formal agreements, the pros of a formal agreement is that it helps clearly identify the supporters, their roles, and what kind of support they will offer. So if for some reason a supporter is overstepping and that they are actually trying to be the ones to make the decision, an adult can point to the formal agreement and say, you signed this agreement and you know what your role is. Additionally, it may be easier to get third parties to accept a decision if there's a formal agreement behind it. Because supported decision-making is relatively new, a lot of healthcare professionals, financial institutions are not very aware of SDM. So having that formal agreement in place that you can point to is especially helpful. Next slide, please. The other thing about the supported decision-making law in Maryland is that it prescribes limitations and it also provides safeguards. So some of the limitations is that the agreement cannot be used as a requirement for participation in a program, activity, or service. And even though an adult is the one who chooses a supporter, there are certain people who cannot be supporters. A supporter cannot be a minor. It cannot be anyone convicted of financial exploitation. And it cannot be anyone who has a protective order against them. Additionally, the way an adult communicates cannot be used as grounds for whether an individual can enter into an SDM agreement or not. So what that means is if an adult communicates in a nonverbal way, for example, through assistive technology, that cannot be used as a way to prevent someone from entering into the SDM agreement. Additionally, even if an SDM agreement is in place, an adult can choose to act independently of it. So, for example, if they have a supporter for healthcare decisions, but for one particular healthcare decision, they don't need assistance, they can choose not to consult their supporter and have their supporter help them with making the decision. Next slide, please. So some of the safeguards of an SDM agreement. So one of the safeguards is that it limits the liabilities for professionals who, in good faith, honor the SDM agreements. But it also limits the liability for professionals who, in good faith, refuse to honor an SDM agreement due to an SDM agreement being invalid. And an SDM agreement might be considered invalid if it doesn't have those formal elements that we discussed. Or if a professional feels that the supporter is overstepping, it might also render the SDM agreement invalid. Additionally, a guardian whose authority is not impacted by the SDM agreement cannot prevent someone from entering into one without good cause. And how you determine, again, whether an authority of a guardian is impacted is by looking at the guardianship order itself. And perhaps one of the most important safeguards, again, is that the supporter cannot make the decision for the adult. It is the adult who makes the decision. Next slide, please. And so another question that I often get asked is what tools can be used in an SDM agreement? What tools can a supporter use? How a supporter and assists an adult is really dependent on the adult. What the adult wants is really important when deciding how the supporter assists. But some of the examples might be providing plain language materials. You know, at the doctor's office, sometimes the doctors are using language that is not very accessible. So having a supporter provide plain language materials can be especially helpful. Additionally, a supporter might create a pros and cons list based on different choices that are available. They might role play the impact of certain decisions. And they might even attend doctor's appointments or other meetings with the permission of the adult and take notes for the adult so the adult remembers all of the information discussed. Because SDM is becoming quite popular, even a simple search on the internet will get you some ideas of tools that a supporter can use. The two tools that I like are the Stop, Look, and Listen tool, which was developed by the South Carolina SDM project. And basically with that tool, an individual determines what skills they want to develop, and then they decide how they will develop those skills. My absolute favorite, though, one is the ARC of Northern Virginia's 100 Ways to Use SDM. And the reason I really like that one is because it divides SDM based off of different decisions. So it's ways to use SDM in relationships, ways to use SDM in education. But again, how a supporter assists is going to be dependent on how the adult wants the supporter to assist. But for ideas, you can just do a simple internet search and you will be able to find some important ways. Next slide, please. So I know I gave a lot of information about supported decision-making, but why is it important? Its importance really goes back to those dangers of guardianship that I discussed. And people with disabilities are regularly subject to plenary guardianships. And it's sometimes based on the bias that the need for supports and the need for accommodations means that they cannot make their own decisions. And of course, that is not the case. Just because an individual needs supports does not mean that they are not able to make their own decisions. SDM kind of corrects the dangers and it solves those dangers. It allows people to exercise greater self-determination that guardianship orders can take away from them. It respects people's voices and their choices, regardless of their age, their disability, or the way they communicate. It helps a person develop and maintain advocacy and decision-making skills over time. And it also promotes the idea that you start with the less restrictive alternatives to guardianship first, and then progress to more if absolutely necessary. And again, I'm not trying to say that guardianship is never the answer. In some instances, it is absolutely necessary, but SDM promotes that idea that you start first with alternatives, that you don't start off with guardianship first. And additionally, you can use SDM now for use in the future. You can use it as a future planning tool. So even if you might not need supporters now, in the event that you might need them in the future, at least you have an arrangement and an agreement in place so you know who will be able to assist you and how they'll assist you. Next slide. So I keep talking about these other alternatives to guardianship. So just in general, alternatives to guardianship are formal and informal options that alone or together allow a person to limit, terminate, or even avoid guardianship altogether. And just like there's guardianship of the person and guardianship of the property, I divide the alternatives up into personal alternatives and financial alternatives. So I'm not going to go into these in depth right now because that in itself is actually its own presentation. But some personal alternatives can be advance directives or medical powers of attorney, where an individual appoints an agent to make their medical decisions in the event that the individual is unable or unwilling to do so. There is also a surrogate decision maker, which is a decision maker appointed under Maryland law in the absence of an advance directive. There is also the Maryland Order for Life-Sustaining Treatment, person-centered planning, and then limited guardianship, where the guardianship order is limited to what is absolutely necessary. On the financial alternative side, there is the financial power of attorney, very similar to the medical power of attorney, but it's related to finances. There's the representative payee program through the Social Security Administration. There are ABLE accounts, the special needs trusts, specific transactions, banking services like direct deposit or credit and debit card limitations. And additionally, there's also limited guardianship for financial alternatives too. Next slide, please. And like I said, you can use SDM with those other alternatives. So for example, with the representative payee, with surrogate decision makers, with guardians, all of these individuals have the ability to make the decision for another individual. But SDM can be used informally to include the individual in the decision-making process. And by using SDM, it promotes the individual's ability to one day make the decisions on their own. For ABLE accounts, SDM can be used so that a supporter can guide and teach the adult how to manage funds, how to budget, how to make transactions. And a supporter can also help connect the individual with financial counseling. And then, for example, for power of attorney, where there are agents, whether it's the medical power of attorney or the financial power of attorney. If the individual is able and willing to make their own decisions, and the agent does not have that authority, the agent can act as a supporter to ensure that others are respecting the decision. But if the agent does have the authority to make the decision, let's say the individual is unable or unwilling to make the decision, SDM can be used informally to include the individual in the decision-making process and show them how a decision was actually reached. Next slide, please. So why use any of these alternatives? What's the big importance of using it? It really comes down to the idea of self-determination. And studies have shown that people who exercise greater self-determination have greater life outcomes. They can live independently. They can work in the community at higher paying jobs and make greater advances in employment. They're more likely to identify situations where they could be abused and less likely to suffer abuse. They also have greater financial independence and better money management skills. They also have greater community integration. So when thinking about the use of alternatives to guardianship and using supported decision-making, it really comes down to ensuring that the individual with the disability is able to lead the life that they want. Next slide, please. So again, I know I gave a lot of information, so I wanted to just put it into the bigger picture and show how it can be used in different scenarios. So the common one that I've seen it being used at is at the doctor's office. So let's say there is a big medical procedure coming up, and the individual is a bit hesitant to consent to the procedure, and they want some help with understanding the recovery period and any side effects that might happen. They might have their supporter write down questions beforehand so the individual can remember what to ask the doctor. They might even have the supporter come into the appointment with the individual, as long as the individual agrees to it, and help them say it in plain language, say it in a way that the patient understands. And to have the supporter at the doctor's office and using SDM at the doctor's office, you don't need a formal agreement to do so. You can make it into a verbal, informal agreement and let the doctor know that the supporter is going to be with you at the appointment. Next slide, please. As I've also been saying, you can use SDM with a guardian. So even with the guardianship order, you can use SDM in an informal way. The starting point, though, is going to be looking at the guardianship order. So where the guardian does not have authority, the individual is in the driver's seat. They are the ones who make the decision. But where the guardian does have authority, they can use SDM informally. And so the individual can work with the guardian to build the decision-making skills over time. Now, under the National Guardianship Association standards, and also just under the responsibilities of a guardian should already be doing this as a part of their responsibilities as guardian, but SDM can make sure that the guardian is doing that. And additionally, an individual might be able to go back to the court to show that the individual can make their own decisions and have their rights restored through either limiting the guardianship order or terminating the guardianship order altogether. Next slide. And so these are just some of the resources that I have found to be helpful. On the Maryland side, there is the Maryland SDM bill text on the legislator's website. And I often counsel my clients to not be afraid to attach the bill text to the agreement. Again, because SDM is relatively new and because it is relatively unknown for a lot of professionals, being able to attach the bill text to show the validity of the agreement is really important. And additionally, on our website, on DRM's website, we have the model form, but we also have some guiding principles regarding supported decision-making. And we have some one-page sheets that talk a little bit more about supported decision-making. But then there are also some general resources that we refer people to. There is the Stop, Look, and Listen tool, the ARC of Northern Virginia's 100 Ways to Use SDM, which I talked about both of those. There is a National Resource Center for Supported Decision-Making. The ACLU Disability Rights Program also has its own library for sources. The Center for Public Representation also has resources on SDM. And what's important also is that the National Guardianship Association has actually endorsed the use of supported decision-making as an alternative to guardianship. Next slide, please. So before I answer any questions, I want to thank everyone. I know that that was a bunch of different information, but I am really happy and to be able to be here tonight to discuss it. So thank you.
Thank you, Sandy, for joining us tonight and giving us such great information about another option for supporting an individual with a disability. So we do have some questions. So I'm going to ask them for our participants. So number one, this is the way we raised our son, but what happens when we are gone? Who is representative to make sure his paperwork is done so he does not lose his housing or other services?
So is it specifically just to clarify, was it specifically talking about alternatives, or is this guardianship, or?
This came in during your presentation.
Okay, so if there is because with supported decision-making, you can have multiple supporters. The supporters aren't the ones who make the decision. So they're not the ones to sign any paperwork. They're not the ones to sign any leases or anything like that. They are just there to help the individual. And if you believe that your son needs help, then you can appoint different supporters and you can have successive supporters in the event that he needs help and you are not there.
So you can have more than one person delegated to be a supporter. Great, thank you. And that kind of leads into this next question. You may have answered some of it. Can you get SDM if the child doesn't want it? Or, for instance, I would have to fight the court for guardianship. I don't want guardianship, but my child will say, I don't need anybody. Can they proceed?
They cannot proceed with SDM without the permission of the child because it is the adult making the adult making the agreement. And because they have to be the ones to choose who the supporters are, you can't force an adult to enter into an SDM agreement against their will or against their wishes.
What is the best way to speak to doctors, vendors, etc. on behalf of your child if you don't have guardianship?
So there's different ways that you can, there's different alternatives that can be used if you need to be able to talk to the doctors. Again, there is there's the powers of attorney or the advanced directives, which is for, that's solely in Maryland, that's solely for the medical decisions. where your child or anybody can appoint an agent to be able to make their decisions if they're unable or unwilling to. So that one, you do not need to petition the court. You can create that agreement on your own. You don't really need a lawyer to be able to create and that's just for the advanced directives. If it's financials, that's the financial power of attorney. That is a little bit different than advanced directives in the sense that the law prescribes certain elements that certain forms that have to be used, but you can find those even within the actual financial power of attorney law or on the Attorney General's website. So with the advanced directives, that would be a way to be able to talk to the doctors without having to pursue guardianship.
Okay. How long does STM last? Do they have to be do you have to reinitiate them or re-up them?
No.
Or can we determine how long they will last?
I don't think that there is a mechanism to at least within the law that has an expiration date when it comes to the SDM agreement. If at some point the adult decides that they don't want the SDM agreement, they can revoke it. But again, that is up to the adult and not the supporters. So whoever creates the agreement, if they decide, I don't want to be able to have supporters anymore, they can say, I don't want to have the SDM agreement anymore. And the supporters have to respect that decision.
Okay. Oops, I just lost this. Is there a difference with person-centered planning document versus SDM as enacted in Maryland in 2022? Is this
Yes, there is
the newest way to assist?
So there is a difference between the person-centered planning and the supported decision-making. Person-centered planning is normally through like the
DDA.
waiver. Through
DDA
DDA,
waivers.
yeah,
Correct.
it's through the DDA waivers. SDM does not have to do with DDA. It does not have to do with it doesn't have to do with Maryland Department of Health or Medicaid or Medicare, because with SDM, it can be used for any sort of decision ranging from healthcare to finances to education. So it is the Maryland law didn't specifically pinpoint person-centered planning, but like I said, you can use person-centered planning with supported decision-making.
Right. And that is the end of the questions for this evening. So I will turn this back to Melissa and Margie in a moment, but Sandy and Dan, thank you so much for this evening. Such helpful, important information for our families. We get many, many questions in the school system about this. So we really appreciate your time. You're coming back year after year to help our families navigate through this. We really appreciate it. I'm going to turn it back over to Melissa and Margie.
Yes, thank you so much, Daniel and Sandy, for your presentation. Just moving forward, the next meeting will be held this Thursday, February 6th at 6:30 via Zoom. The webinar will be focused on financial planning, special needs trust, and ABLE account. The webinar will feature Yolanda Mazik, CEO, Shared Horizons, Inc., and Kelly Nelson, Outreach and Community Manager, Maryland ABLE. If you have not already, please register for Thursday's webinar. We will be providing ASL, Spanish, and Amharic interpretation again, and we hope to see you on Thursday, and have a great evening.